Hello and welcome. I am Ali Goff. I'm the owner and founder of Goff Legal, and I would like to share with you today a little bit of information about taking title to property with children. There should be a big old warning sign that comes across the bottom that says, don't do this ever. Just kidding. It's not that you can't do it ever. It's that there's some really important things you need to know if you are thinking about taking title to real estate in California with a child. This actually could apply to many other people, but I'm really limiting this to children. So one of the things people want to avoid in California is probate. The probate process is time-consuming and expensive and pays the lawyers and the government a whole lot of money and leaves less for your family members. So one of the solutions that some people have thought about is, if I put my child on title to the house when I buy it, or sometime after, I will add them on. When I die, they get the house. No probate. That's true. Good job. You avoided probate. Here's what you need to know about that, though. The first thing is, if you take title with a child and something happens to them, meaning they get in an accident or a lawsuit or there's a judgment against them, your property is legally half theirs, and it might be used to satisfy a judgment. So that's not a great thing. The second thing is, we're going to get some tax law here. If you add someone onto title to your property, let's say you bought it for $500,000. If you give it to them and then you die, their basis in the property is $500,000. Let's say you bought it with them, and then you live for another 25 years, and the property's now worth $1 million. When you die, their basis in the property is $500,000, and they sell it for $1 million. The capital gains is $500,000. It's a lot of money. Now, that's not the tax due, but that's the amount that is taxed. If instead you give your child real property on your death, they get an adjusted basis to the date of death value. So you have a house, you die, then your child inherits it at $1 million. They sell it at $1 million. Their capital gains is 0. So you need to think about not just the probate issues, but the tax considerations as well. The other thing you should know is, if you have multiple children and you put one of them on title to the property, they don't have any legal obligation to share it with your other children. They legally get to keep it. This works for cash accounts too and investments. If you list a child as a beneficiary, if you bring them on as a joint owner and they're the surviving joint tenant or their only beneficiary, legally that account is theirs and they don't have to give it to anyone. And the other thing is, if they were to decide to give it to some of their siblings, there are gift tax implications for those types of transfers. But if you give it to someone after your death, either via beneficiary account or via trust, you avoid the gift tax issues for your child, the creditor issues while you're alive, and also the tax basis issues later on. I hope this has been helpful. One more tip. Never, ever, ever add your minor child on as an owner of your real estate, or you will have serious problems when you try and sell it or when you try and refinance it, because minor children cannot hold title to real property in California without a very specific way of doing it. And I'm promising you just adding them on is not the way to do it. So please don't do that. Please consult with an attorney to talk about your options regarding how to hold title in real estate if you're considering purchasing a house in the near future. If you'd like to chat with one of our attorneys, our website is gofflegal.com. Thanks so much. Bye.